Division single division होगा ना? My lord, on extreme urgency, my lord, kindly allow me to mention what. Kindly allow me to mention one applied matter, my lord. My lord,
What is the urgency?
urgency is by the impugned order, my lord, the honorable single judge misdirected himself on the point that I filed a preemption application, lost, my lord, on the ground of short deposit, but co-sharership has been, my lord, declared. On the ground of short deposit, it has been dismissed. By against that, I preferred my revision that is pending. Suppressing all these material facts, my lord, only saying that husband of the
What is the order impugned? What is the order passed?
order passed directing to render police assistance to the lady to, my lord, to construct his house, and now the contempt has been filed. Yesterday police came to me, in my
Where is the contempt scheduled?
contempt, my lord, is, my lord, kindly have a look to this order, my lord.
No, when the contempt application is coming up.
Already order passed, direct me to arrest if I cause disturbance. My lord, nothing. My lord, my co-sharership has been declared. I have filed partition suit. My lord,
Show us the order.
yes, my lord. अरे weird order था देखो, written order था. This is the order passed in reach court.
Have you filed the appeal?
Yes, my lord. It's old, my lord. We don't know.
It is appearing under what item number?
My lord, it is not in the list, my lord. I am praying, my lord, to move the matter on list because, my lord, any moment.
Why did not mention it earlier?
My lord, we have no idea, my lord. We have no idea. In contempt, we are not party. So we have no idea. Yesterday, police came to our home and said, my lord, they will construct, will not, and particularly the plot is Doba.
So this is the original order. Where is the order passed in contempt?
That has been handed. Contempt order to them? Yeah, yes. Complete suppression, my lord. On the basis of suppression, this order has been passed. And record is Doba. On the Doba land, how can a person without any conversion, my lord, can construct? Many things, my lord, to argue. I am co-sharer. I have been restrained by the police, by the impugned order. And now the impugned order being carried out under contempt. I will not get party injunction anywhere from the landed court below because of the High Court's order. Where from the honorable single bench got we extract money and everything. Even in the two deeds, well, schedules are different. Many things to be said in the trial court, in the partition suit.
But this order, according to you, was contempt application.
I have challenged the main order. If the my lord finds my lord main order to be stayed, then contempt automatically will be stayed. In contempt, my lord, this type of order is being passed. To lodge FIR, depute police, only sole on the basis of sole contention, we lost in the two courts. In what matter we have lost?
Have you served a notice upon the other
Yes,
side?
yes. Notice is there, my lord. Yes. Everything has been served. Notice, my lord. This is the WhatsApp.
Who is appearing for the
petitioner?
Petitioner?
Vasabi ki naam?
Lokshinath Bhattacharya.
Bongsivadan. Lokshinath Bhattacharya is the senior. Bongsivadan is the advocate on record. We have informed him.
Yes.
We have also informed you. Kindly, my lord.
And state.
My lord, I will check up and my lord.
Yes.
12
where is the file lying?
My lord, I will bring. I will try. In the department, my lord, it will be, my lord.
In the department. Let it appear on Monday.
My lord, at 2, I just.
What will happen today?
My lord, Saturday, Sunday, my lord, kindly see the order passed in the, my lord, contempt application. Police has come yesterday and every day. Police is threatening us to, my lord, leave the area.
Mat number?
Inform
the state advocate as well as the.
Yes, my lord.
Have you served the copy of your stay application upon them?
Yes, my lord. Yes.
When have you served?
Yes, my lord. Yesterday, my lord, I have already served with the notice in WhatsApp.
WhatsApp.
What I served.
When have you filed this appeal? appeal, when have you filed this appeal?
অ্যাপিল কবে ফাইল করেছিস?
স্টে ফাইল হয়েছে, স্টে আছে।
It was filed, my lord,
কেস নাম্বারটা
2518 of 2023.
2023, and you have not moved.
My lord, kindly appreciate. My lord, kindly
Monday.
appreciate.
No.
My lord, kindly appreciate, my lord.
2023, what were you doing till
My
this
lord, I
day?
mentioned before, my lord. I mentioned before the honorable bench, my lord. Matter is,
2023,
my lord, kindly appreciate, my lord.
no, Monday.
My lord, kindly appreciate, my lord. My lord, kindly
It appear
appreciate.
on Monday.
My lord, kindly appreciate, my lord. One thing, my lord, I tried to mention before
When
the
did you last mention?
my lord,
When did you last mention?
my lord, perhaps 2-3 weeks ago, my lord.
2-3?
Weeks ago, because my lord, there was, my lord, the difficulty was about this contempt.
When did you file the appeal? And when did you first take steps for moving that?
My lord, I have filed, my lord, contempt, my lord, section 5 application also,
Yes.
and stay application also.
New matters, it automatically comes. When have you filed this application?
Application গুলো করা হয়েছে। দেখো, can গুলো কবে ফাইল হয়েছে? Can গুলো কবে ফাইল হয়েছে? In January? My lord, in January, my lord. Can তো কবে ফাইল হয়েছে?
When have you filed the appeal?
Yes, my lord.
When have you filed the appeal? You cannot give us the date of the appeal. Filing of the
Appeal
appeal
filed
also.
on, my lord, 21st 12 2023.
21st 12 2023.
Yes.
And why did you not mention for this long time?
My lord, I have mentioned, my lord, but
It automatically comes. New matters, applications, it automatically comes.
my lord,
If you have mentioned,
can one,
it's
can
not
two,
that hearing matters, maybe, but new matters, it automatically comes if you have
my
mentioned.
lord, in perhaps in January, my lord, it has been filed in can 1 and can 2, my lord.
So-
Can 2,
Can
can
one,
2.
So you have filed the appeal in December.
can one ফাইল করেছে।
With a prayer for condonation, the condonation delay application you have filed in January.
One was filed, my lord.
23 ফাইল করেছে।
Can my lord file one condonation of delay along with the appeal? It has
Along
been
with
filed.
the appeal.
Yes.
So why did you not mention this? And you have also not moved the stay application.
Stay
Let
application.
it appear on Monday.
My lord, kindly appreciate, my lord. By this time, my lord, police, my lord, kindly see my lord, the order passed in contempt, my lord. Kindly see.
You did not also mention yesterday. Yesterday also you did
Yesterday,
not.
my lord, yesterday police came, that is why we rushed to the.
No, the order was passed long back.
We do not know. We do not know, my lord. In contempt, we are not party, my lord. In contempt, we are not party.
Contempt, you are not party.
No. Only police. Police came yesterday and shown us to this order and said, leave this area. Otherwise, we will be arrested as per the order.
Let it appear on Monday.
My lord, kindly appreciate, my lord. Let the file come, my lord, kindly at 12:30 or in the meantime, I will complete everything, my lord. I will bring my other sides, my lord.
একটার সময় রেখে দিন।
এখানে সব নাম্বার
Subject to your informing all the parties,
Yes, my lord.
state
Yes,
and the writ petitioner there, subject to that.
at
One.
Great question, my lord.
Any other mentioning?
Any other mentioning regarding first division bench?
Yes.
Lordship, with your kind leave, may be permitted to mention a matter for inclusion, CO of 2023, wherein an issue, a CO of revision of 2023, when an initial question cropped up as to whether the time limit for complying the mandate under Section 7(1)(c) of the West Bengal Premises Tenancy Act can be extended. The issue had since been referred before the larger bench, and it was held that it cannot be extended, as this is a mandate. I'm for the landlord, your Lordship petitioner.
No, is this matter assigned before me?
Yes, your Lordship's order, yes.
Yes, you are for the
Petitioner.
petitioner.
Yes, your Lordship.
You have served this.
Yes.
No, but there was a direction to appear before the regular bench.
Right.
List before the regular bench.
For the regular bench.
Some matters were released from the regular bench on the ground that once assigned, they will be taken up by your Lordship. Then my matter was also released. Then, my Lord, yesterday again that has been listed.
No, some matters have been assigned, but in matters you will be finding that kindly take up the note in the list.
My Lord.
The following matters which were assigned by the administrative order dated such and such be treated as special if is
Specially assigned,
to his lordship, if not otherwise ordered
judicial.
judicial. So judicially it has been ordered
Right.
to appear before the regular bench. So this will not be treated as specially assigned.
That part is there. That was missed.
That's fine, Lordship.
Can invite the attention of the honorable
Fine,
judge. If,
No, Lordship listed the matters on the following day.
yes,
The
because
first day it was released, then the next day it came up in the list automatically. So this was noticed and
yes,
Item number 1.
one would I beg to appear for the petitioner, my Lord. This
Yes.
matter where the question of my Lord applicability of Limitation Act arose. Have had a discussion with my client, my Lord. Lordship, we shall concede to the Section 5. Kindly expedite the appeal. And Lord, we have taken a point of maintainability of the appeal also.
all
because-
points will be kept open.
including point of kindly mention that because our point is, my Lord, that the owner has
Integrity of the appeal.
appeal because he has no right. Owner.
What happened yesterday?
Yesterday, my Lord, a date has been fixed. The next date I couldn't not gather, but the interim order was extended.
Interim order was
Yes, and a
extended.
date has been fixed.
You did not oppose the prayer for interim order.
By the
Extension.
time it was taken up, my Lord, in view of the pendency of this matter, my Lord, mechanically, my Lord, they're extending the interim order and waiting for the outcome. So, Lordship will not kindly.
Have you raised the point of maintainability of the appeal in this objection to the stay application or anywhere else? Have you filed, have you
No,
annexed the
objection
copy of
to-
the objection?
Objection to stay has not been filed, my Lord.
You have
We shall
not filed?
We shall file within 7 days. Within 7 days, and the point of because
Are you sure you have not filed any objection?
I would just for that. He will take instruction.
Take instructions.
Because my Lord, my specific point is that, my Lord, under Section 218, owner is to be given a hearing. Owner can prefer an appeal in order passed in this figure. So owner has a right. Owner has exhausted that right.
Yes.
No appeal. Then, my Lord, the developer who is the power of
I'm
attorney holder-
recording that you are not challenging that part of the extension of allowing the section 5. Condonation part you are not challenging. I'm recording that.
Condonation, my Lord, kindly records. And
Ashwin.
I want an end to it, my Lord, because
That is why I adjourned this.
2016 demolition
That
order.
is why I adjourned this. Because I think
That is the
at
most.
this point of time, no use in vacating the original order.
Fine.
Subsequently, it is being extended. Get the miscellaneous appeal.
And Lord, the mandamus appeal is pending. I shall pray for adjournment of the mandamus appeal because, Lord, depending on the fate
That
of
is
the
up
appeal,
to you. That you take steps.
depending on the fate of the appeal, the Lordships will pass the order. Because, Lord, even if the appeal, there is some lacuna, then also, Lord, the ultimately proceeding for demolition has to be concluded. So, Lord, I'll pursue my remedy before the division bench, but so far as the appeal is concerned, Lord.
The order number 2, dated August 28, 2023, passed by the Learned Civil Judge Junior Division, First Court Srirampur, District Hooghly, in Miss Appeal number 8 of 2023 is under challenge in this civil order.
Could not contact the client, right?
In this civil order. Full stop. By the paragraph. By the said order, the prayer of the opposite party number 1 herein for condonation of delay under section 5 of the Limitation Act stood allowed. By the thereafter, the application for stay of the demolition order was moved on 28th of August 2023, and in the later part of the order, in the later part of the order, the learned trial, the learned court below, learned judge of the court below, passed an order of stay of the demolition order dated 8th September 2016 for a limited period. Being aggrieved by the said order, the complainant in the complainant of the complainant before the municipality, which gave which culminated in the order of demolition, has approached this court. This fact is correct. To stop. Paragraph. Mr. Banerjee, learned advocate, appearing for the petitioner, submits that challenging an order of demolition dated 8th September 2016, passed by the
That is the communication. Resolution
by the
30th
that is
August.
also that, because board resolution also
Board
is
resolution
same date.
says no. Board resolution date is not 30th of August. Page 56. Notice 8 September. Resolution
Page
56, my lord.
But Mr. Banerjee, the stay has been on 8th September. So you can take advantage of that.
Stay is on.
Stay is
Not on.
so I can record your submission. Mr. Banerjee submits that learned advocate for the petitioner challenging to na kore submits that the Board of Councillors of Uttarpara Kotrang Municipality passed an order of demolition dated passed an order of demolition on dated on August 30, 2016, which decision was communicated by memo dated 8th of September 2016. Stop. Such communication was under challenge. You have got the memorandum
No,
that it
That is
was
not-
only challenged.
that is not there, my lord. Not an act.
at the instance of the opposite party number 1 herein, in a proceeding under section 218 within bracket 3 of the West Bengal Municipal Act 1993, which was before the Learned Civil Judge Junior Division, First Court at Sirampur, which gave rise to misappeal number 8 of 2023. He further submits that by referring to the order dated 25th August 2023, passed in miscellaneous appeal number 8 of 2023, Mr. Banerjee submits that though 29th of November 2023 was fixed for service returns and acknowledgement due, but the Learned Court below took up the hearing of the application under section 5 of the Limitation Act only on 28th of August 2023, that is long prior to the date fixed, and allowed the same. He submits that the delay could not have been condoned without giving an opportunity of hearing to the petitioner. However, taking into consideration the fact that the Mr. Banerjee, after taking instructions from his client, submits that his client is interested in expeditious disposal of the miscellaneous appeal and do not wish to assail the order condoning the delay in preferring such miscellaneous appeal. He submits that the ad interim order of stay of the demolition order was also passed on 28th of August 2023 without giving any opportunity to the petitioner to contest the same, and such order has been mechanically extended from time to time. Mr. Banerjee raises an objection as to the maintainability of the miscellaneous appeal at the instance of the opposite party number 1 hearing. Considering the fact that the appeal is that the miscellaneous appeal was filed sometimes in August 2023 and challenging an order of demolition, this court feels that the interest of justice would be subserved if a direction is passed upon the learned judge of the court below to dispose of the same expeditiously. In the event no objection to the application, Mr. Banerjee submits that yesterday, that is 29th of February 2024, was the date fixed for hearing of the stay application, and he is not aware of the next date fixed. In the event an objection in the event objection to the stay application has not yet been filed, comma, the same shall be filed within a week from date upon serving an advance copy of the same to the learned advocate for the appellant in miscellaneous appeal number 8 of 2023. It will be open to the petitioner herein to raise the point of maintainability of the miscellaneous appeal either in the objection to the stay application or by way of filing an independent application. And if such objection is raised, comma, the learned judge of the Court of Appeal below shall decide the same prior to extending the order of stay already passed in the miscellaneous appeal. Full stop. This court, Mr. Banerjee, I can only direct expeditious disposal of this proceeding. I do not know whether you have come across the order of the Honorable Supreme
Yes.
Court passed yesterday.
That is, my lord, mentions in exceptional circumstances it can be passed. So this is not an exceptional circumstance.
Mr. Banerjee, maybe
No, this falls within the, my lord, bracket of exceptional, my lord, because it mentions unless it is exceptional. So that, my lord, that leverage is there, my lord. This is exceptional, my lord.
considering the fact that the delay in considering the fact that the delay was condoned without giving an opportunity of hearing to the petitioner, and also that the order of stay was passed preponing the date fixed by order dated 25th of August 2023. This court is of the considered view. And also taking into consideration the fact that an order of demolition passed sometimes in the month of
August 16.
August 2016, which has been challenged only in the year 2023.
It has not, they have challenged, my lord, only
Challenged at the instance of
only the notice. They have challenged. I found the memo also. Anyway,
thing,
that is
because
another ground.
which has been challenged at the instance of the opposite party number 1 herein only in the year 2023. This court is of the considered view that the instant case is an exceptional case for which a direction is to be passed upon the learned judge of the court below to dispose of the miscellaneous appeal within a specified time limit. Full stop. CO number 3415 of 2023 is disposed of by requesting the learned civil judge, Junior Division, First Court, Srirampur, District Hooghly, in this appeal number, District Hooghly, to take up the to dispose of the interlocutory applications as expeditiously as possible and preferably within a period of 6 weeks from the next date fixed.
Only the interlocutory, my lord.
If you file another application for, if your objection has been filed, you want to file an maintainability.
Your lordship gave me, but
4 weeks from the
no, I was saying the main appeal, maybe, my lord. Both can be taken up together.
Objection, if it is maintainability, gone. Because I do not know whether the appeal, other parties have appeared, it may be a difficulty in taking up the hearing of the appeal.
Municipality has appeared, we have also appeared. তো কোনো party নেই।
So I'm directing thereafter,
Fine.
ওটা 4 weeks করে দিন without granting any unnecessary adjournments to either of the parties. In the event, the decision on the point of maintainability of the appeal is in favor of the opposite party number here, one herein, comma, the learned civil judge, Junior Division, First Court, Srirampur, shall dispose of the miscellaneous appeal as expeditiously as possible, but positively within a period of, preferably within a period of 8 weeks from the date the appeal is ready for hearing. With the above observations and directions, the appeal, the CO number such and such stands disposed of. আচ্ছা, একটা order record করে দিন। What did you say that who has said that he has no instructions to appear? Service has been complete.
Service is complete. The file the caveator,
Everyone has been served.
lawyer appeared and
একটা মাঝখানেটা লিখে দেবেন, in spite of notice,
instead of
none appears for the opposite parties hearing. ওটা মাঝখানে
that we have filed the affidavit of service.
when have you filed?
No, the last occasion. আগের দিন, হ্যাঁ,
Yesterday?
yesterday, my lord.
আচ্ছা, if you-
Those are on record.
দেখে নিন।
Yesterday, your lordship recorded possibly, my lord.
I've recorded yesterday.
Yes, last night I have
In
recorded.
spite of তাহলে ওইটা line. In spite of notice, none appears. Yes, next.
Deeply obliged, ma'am.
Respondent, my lord, these are review.
Item number 2. But this is a review application, my lord. But I was saying if this can be taken up on next Thursday, my lord, should be sitting on Thursday. So it can be taken up.
Thursday.
Or next week, on any day next week, my lord, can it be taken up? But an interim order was not brought to your lordship's notice while disposing of the matter. On that ground, we have preferred the review, my lord. It's a mistake on the part of the advocate, my lord. It could not be brought to the notice of the court while disposing of the matter, my lord.
So what could not be brought to the notice?
A interim order passed in the matter, my lord.
Interim order. What was the interim order?
My lord, my right was reserved that if the petition is ultimately disposed of in my favor, all the dues will be released to me along with interest. So, my lord, lordship has not considered that as interim order, my lord. That on that ground, we have
All right. Thursday.
Thursday.
Get as on the prayer of the learned advocate for the review applicant, list this matter. Next Thursday date করে দিন। On such and such. Yes, next.
Item number 8.
I'm for the opposite party.
Who is for the petitioner?
My lord, your lordship remember,
Mr. Arindam Pal. He appeared yesterday.
yes, my lord,
Have you got a copy of this?
yes, and it was my lord taken up before my lord vacation. So, and you were also in the mood of dismissing. He took time. He took time for further argument. Maintenance, regarding maintenance, my lord, 7,000.
But he is not here. He appeared yesterday.
All right, my lord.
Making it not today?
All right, as you know.
Not today. Next.
Item number 9.
Pass over. Next.
Item number 10.
Pass over.
Item number 13.
Yes.
I appear for the opposite party. Is that matter that 30 rupees less?
Where is the petitioner?
Instead of 972, the clerk made mistakes He read it 942, he went on paying. Initial deposit was correct in
Ask
between.
your junior to inform him. Do you have his mobile number? Call him. So Bandhavadda, you can start with regard, because this is the legal issue.
These are legal issues, one of the facts are
Facts are admitted. According to
admitted.
you,
Admitted.
you have admitted that the amount directed to be deposited was not deposited.
Yes,
There was
970.
a short deposit, and you
Yes,
came to know.
it's my submission that it cannot be treated as a default under 712. So question of striking out of my defense doesn't arise. And he relied on this Honorable Supreme Court's judgment 2019-10 SCC saying that the limitations will not be applicable. It is now the same view has been taken by the special bench of the division bench of this Honorable Court. But even going through those two judgments, it will be the absolutely different aspects of the matter.
Make your submissions on that. I think he will be relying only on that, because you have to distinguish.
I can, I have in fact prepared all against. It's coming,
It's coming. All right, you proceed.
But I have made a compilation, incorporating all decisions against me also.
Yes, that's better, because he will cite, unless even if you do not cite, he will cite this.
But so far as the first judgment, kindly take AIR.
No, first, do you have a copy of the Premises Tenancy Act? Ache? At Premises Tenancy Act 1997 Act একটা আনিয়ে নিন না, আছে কি? এটা কিন্তু কারোর একটা বই বোধহয় মনে হচ্ছে। ওই বইটা কে দিয়েছিল? ওপরেরটা আমাদের কোর্টের বই না? ওপরে হলুদ বইটা কার? না না, ওটা কার? আমাদের কোর্টের বই কি? কোনো উকিল বাবুর বই বোধহয়। বোঝো ঠেলা। Premises Tenancy Act আছে এখানে? 1997 Act একটা আনিয়ে নিন তো। So Bandhavadda, you have an extra copy?
No, I don't have, but your lordships can take it. This will cover under 7.3.
একটু দেখতে বলো না, ওই তো আছে না, ঠিক আছে। ওইখান দিয়ে পারবে না, ওখান দিয়ে পারবে? ওই এটাকে উঠতে বলো না।
Your lordship can take it, এটা দিন না।
ওদের বলো তো ওখান থেকে দেখতে।
পারবে কিনা।
Mr. Bandhavadda, you have to make your submissions as to whether proviso to subsection 2 of section 7 can be a bar in this case in extending, because your argument will be that under 151 court has the power to extend.
Or I should say, it's a sufficient compliance. There was purely an error. There was no default at all. Instead of 972, the clerk read it 942, and there was no default for the initial 2 months, and subsequently also it has been correctly deposited.
No, initial 2 months I could not follow. Initial 2 months.
I'm just giving the facts,
No, initial 2 months means
after the High Courts gave directions,
initially for 2 months you
correctly
deposited at the correct rate.
Correct rate.
Thereafter, there was
Thereafter, from 2016 to January 2021, 57 months, all along the clerk went on depositing 942. Thereafter, again, the correct amount was deposited. In my humble submission, 7.1 and both 7.1, those directions cannot be held to be not complied with, because it was deposited within time.
What is the meaning of compliance?
Compliance means the court had held this is sufficient compliance. I would say the doctrine of substantial compliance, because there's omission.
Now your defense, the issue is whether your defense can be struck off or not.
Yes.
Kindly come to say you do not have a book.
No, I can read it from the phone. Kindly take
Subsection 3.
Yes, subsection 3.
Fails to deposit or pay the amount
Any amount referred
to in subsection 1
within
or
the time
subsection 2.
specified therein, the amount was directed to pay 972. Now, according to me, it was deposited, but the wrong amount.
So then,
Yes.
how can you come out of this expression? Pay the
As
amount
may be
referred
granted, the
to in
con-
such and such within the time
Yes,
specified.
controller shall order the
So
defense
it's only not the time. Mr. Bandhavadda, it's
No,
only
no.
the time.
or
Amount referred to.
then within the time specified there,
Yes, yes.
or within such extended time.
Yes. So within such extended time is because of this proviso.
Because of this provision.
Proviso allows, so let us suppose there was an original order
Yes.
which allowed you to deposit, let us suppose within 31st of January or within 29th of February. So, but you have deposited a part, you could not deposit a part, you come up with an application. So it was extended, said yes, you deposit within 31st of March.
Yes.
And you deposit within 15th of March. So it falls within that extended time.
Yes, my lord, here also,
Now
my lord,
the question would
my lord,
be,
here also, my lord, the first time that mistake was detected, I filed an application, then court extended.
yes, that is the catch.
My lord, that
Whether
is,
the court,
that-
after this 1 month, can further extend.
no, that is within this subsection 3, within such extended time.
No, such
That was
extent.
the,
No, according to you, you are trying to make out a case that under section 7(3), there is a further
extension, permission. If the courts,
there is a further scope of extension under section 7(3).
my lord, I am not also on that. My lord, kindly take this Patna judgment, my lord, I have handed over
Yes,
this
yes.
compliance, my lord, 76
Mr. Bandopadhyay,
Patna.
have you given a copy to Mr. Bandopadhyay these judgments? No.
I have,
I think he must be knowing because
I-
he is regularly appearing in this.
I have prepared it for
You have
him
prepared.
also.
All right.
Compilation.
You are not here, my lord. But only one judgment I got, my lord, there is the first judgment in this, my lord, on these facts. No other judgments. I have searched.
In Patna,
Only Patna on the same fact.
provision is similar, perimeteria.
Similar provisions.
Show me that.
The facts that the petitioner had come earlier to this court,
Which
my lord,
page?
first judgment, my lord, first
Oh, first
fact,
judgment.
first judgment.
Yes.
In this application, defendant, the only question is as to whether he committed any
So,
default.
Mr. Bandopadhyay, you are for the opposite party.
I'm for the opposite party.
Mr. Bandopadhyay, do you want to start?
Yes.
Because since you are not here, I asked Mr. Bandopadhyay to start. All right, you can make your submission so that Mr. Bandopadhyay can.
Yes. And the last flag, you'll also find the.
Do you have a copy of the Premises Tenancy Act?
Got
No, you can. I have one because if Mr. Bandopadhyay requests, kindly share it with Mr.
No,
Bandopadhyay.
I have my lord from mobile. Or I can ask for a copy. It must be 97 with ID data.
ওখান থেকে পাবে না গো, অত হাত থেকে ফেলতে বলো, একটু উঠতে বলো। Yes, Mr. Banerjee.
Sorry, my lord, I could have brought it.
So I have to check. One is Mr. Banerjee, one is Mr. Bandopadhyay.
Our university had changed it to Bandopadhyay. But since thereafter I have come out.
Oh, you have been changed to Bandopadhyay?
No, thereafter I have come out.
Initially, you were Bandopadhyay.
Initially I was Banerjee.
Yes.
But when the registration certificate is done by the
Bandopadhyay.
Calcutta, it was made Bandopadhyay and the spelling of my name was also changed. Then I had to give a representation. That representation was not allowed by the
According
university.
to you, Banerjee stands on a higher footing than Bandopadhyay.
Everybody in my family writes Banerjee. So what can I do?
Yes.
I could not have been an outcast.
Yes, Mr. Banerjee.
Well,
In fact, my father wrote Banerjee. But my title became Bandopadhyay
University made
from
it Bandopadhyay.
class 10, after class 10. Even my birth certificate says Banerjee.
It happened in my case also, my spelling has been changed.
Yes, by the university. That is because I later came to know that Sir Ashutosh Mukherjee had given a code of this spelling. For that reason, it is all changed.
Yes,
Now, later it has been, discarded. Now the spellings that are there, those are retained.
Yes.
Now, my lord, my point before your lordship is very short and very simple.
Facts are admitted.
Facts are admitted. But there was I just want to highlight one or two facts which are very essential. The 7-2 was disposed of by the learned judge 6th bench at a time. But I've given the facts in a nutshell in one of my notes. I will share it.
You can give it so that I need
Absolutely,
not make a
sir.
note of that.
Absolutely. But I have not tagged it. I have given a clip because the judgments can be taken out for better appreciation.
So,
Sir,
will you refer to all the judgments or you will take a decision according to that.
No, no.
Then you can give me only one thing. You give me only the notes for
Very
these
good.
dates and other things.
Absolutely, my lord.
You can take.
My lord, kindly.
All right. Yes.
My lord, at the time when the 7-1 was filed, my lord, the defendant quoted a specific quantum of rent. That this is my rent, kindly
Let us
permit.
not go back to that.
My lord,
So
that is
now-
important. That is important. I will not take more than a minute for that. But while deciding the 7-2, the learned judge in the court below adjudicated the quantum in the perspective of the maintenance charge and the proportionate municipal tax, and arrived at a quantum which is different from that what was stated in 7-1 application. Malad, this is very important. The quantum is different. So there was an adjudication with regard to the quantum, and that quantum they started depositing before the court below in compliance to the 7-2
For 2
order.
months, Mr. Bandyopadhyay said for 2 months.
More than that. More than that. I have given how many months?
All right.
Madam,
So let us
once
assume that after by 7-2, the quantum was fixed. He accepted that and deposited for a certain period of time at that rate. Subsequently,
Madam, initially did not deposit. Preferred a revisional application before the High Court.
yes, High Court affirmed that. Thereafter, he
High Court affirmed that,
extended that time.
extended the time.
Yes,
And thereafter, he paid the entire arrears and continued to pay
at that rate.
at the rate which court adjudicated.
He paid the entire arrears.
Yes,
No, so arrears, there is no that was within the time.
within extended time.
Extended means High Court's extension.
High Court's extended
Yes.
time. I have no
Uh,
grievance to that.
No, I'm not on that. So I want to clear some facts. So 7-2, let us assume that X amount was directed
Yes,
to be paid within Y period.
yes,
So he has deposited the X amount within the Y period.
by the extended time of the high, as granted by
Y
the high.
period. Let
Yes.
us assume that the High Court's order is the final order.
Yes,
So with that is the time he has to deposit X amount within Y period. So
Yes,
he has
sir.
done that X amount within Y period.
yes.
Now, the rate suppose was decided to be rupees A. So he initially deposited for few months at rupees A. Thereafter, he started depositing at A minus B.
A minus B.
So these are the facts.
These are the facts.
Yes. So according to and thereafter, so this difference of A minus B, this differential amount which is D. So he according to him, this was detected subsequently, and he wanted to deposit this amount with a prayer for extension at a point of time when you file an application under section 7.3.
No.
Prior to that.
Prior to that.
So at that point of time, you did not file 7.3.
But may I just place the facts? my lord?
He was also not aware.
No, that is so. But no, this facts 7.3 was not there.
No.
So he filed an application for extension, maybe under what caption? For extension. After, according to him, he came to know and he's filed. But as on that date, 7.3 was not there.
7-3 was not there. 7-3 was filed later. Both were,
Hard
disposed
analogous.
of together.
Yes.
Yes. But my point before your lordship is that he has given 3 grounds for,
Yes,
he has given 3 grounds
for not depositing at
for
that
not
rate.
depositing at that rate. The first ground was the clerk was depositing, the clerk wanted to save his job. So in spite of having knowledge that he is depositing at an incorrect amount, did not disclose that either to the client,
His job, I could not make out that.
because the advocate would have fired him. If he would have disclosed before the advocate that I have deposited the amount at a lesser rate.
Yes, now I follow.
This is the first ground. The second ground is it was kept in the advocate's chamber. Advocate did not open it. The client,
The client also could not have known this.
no, client did not look for it. Client did not take it.
Yes.
Client did not look for it.
So client was also not aware. Let us take it at that.
That is the ground. And another ground is the clerk of the plaintiff's advocate
That is your advocate, your clerk.
gave information to them that you are depositing at a incorrect amount.
That is the knowledge.
They say.
That is the starting
But
point.
these are the three grounds that they have
So
tried
you will
to.
be arguing that this cannot be said to be a bona fide ground.
That is my first point. But that is factually. I will then.
That is why. That is
Yes.
factually.
Yes.
So first proceed. There are two aspects. If in law extension can be granted, then we can look into the factual aspect. Otherwise, it's unnecessary to look into those factual aspects.
My lord wants to see the law first of all.
Yes, because law, if it is that it cannot be extended, you
Lordship.
can make your submissions on the bona fide aspect as well, because it will be decided once for all. It's not piecemeal. So first, on the point of law.
Absolutely.
I will ask Mr. Bandyopadhyay to reply on the point of law. Thereafter, you can make your
Very well.
submissions.
But very well. I have noted.
But it will be decided once for all.
Absolutely.
Yes.
Lordship will kindly come to a Supreme Court decision that is reported in but the second judgment that I have given to your
Your
lordship.
punch.
Yes.
Mr. Banerjee, is this matching the order judgments? Which one are matching so that I can follow only one?
Yes.
Otherwise, it will be. You
Yes,
can check.
That is matching. The same judgment
2019 will match, but the others won't.
All right. So which one will match?
But the item number 2 at page number 7, this will not match.
Of your judgment.
Yes.
Only this will not match.
No. Other 2 also will not match.
All right. You place from your judgment.
2, 3, and 4 will not match.
All right.
1 will match.
All right. You
Lordship.
place in your own way.
My lord comes to this 2024 judgment.
2024 2.
Yes.
Yes.
Supreme Court cases, page 169.
Yes.
But I would only reiterate upon paragraph numbers 15, 16, 17, and 18.
Paragraphs 15 to 19.
15 to 18.
18. Yes.
But the 18 is the most relevant.
Yes.
I would only place that, my lord. Lordship will kindly go through the other paragraphs also, from which the Supreme Court comes to this finding. This is the latest that I have found out, 24.
Yes.
But the compliance of a 7-2 order,
Nasiruddin was considered.
everything was considered. Nasiruddin was considered, Chamaria was considered, everything. Kindly sees the 2 lines. The
Which paragraph?
but para 18, page 175.
Yes.
There is also a larger context in this behalf, as the Tenancy Acts provide for certain protections to the tenants beyond the contractual rights. Thus, the provisions must be strictly adhered to. I'm insisting upon that. But whatever order is passed,
Yes. Yes.
Lordship is aware that strict adherence has to be made to. This is in perspective of West Bengal Premises Tenancy Act 97.
This is, I think, very important. The tenant is thus required to deposit all areas of rent where there is no dispute on the admitted amount of rent, and even in case of a dispute.
Yes.
So, in case of a dispute also, what amount is to be? There cannot be an admitted amount.
No.
So, what will be the
But here in our case,
this judgment? I'm asking
yes,
you.
yes.
How do you explain this?
But
The
when there
tenant is thus required to deposit all areas of rent where there is no dispute on the admitted amount of rent. So, admitted amount cannot be a dispute because admission has to be of the tenant.
but even
Because
if
you are filing the suit, you are alleging that 7 months, 8 months is a default and this is the rate of rent. He admits that. So there cannot be any disputes. So admission has to be by them, cannot be by you.
Yes.
So if he admits, there cannot be a dispute.
But even if there is
So,
admission,
but on the admitted amount of rent, and even in case of a dispute, what do you mean by this? Even in case of a dispute, what is to be deposited?
the amount that is adjudicated by the court.
So not at the stage of filing of an application under section 72.
After adjudication of the 7.
But this does not say after adjudication. Mr. Banerjee, after adjudication, it's adjudicated.
Yes.
So then the question of admission, dispute there is no question of that. Once a dispute stage is prior to adjudication.
Absolutely.
Once it's adjudicated, it does not remain a dispute.
Lordship.
So this dispute refers to at the filing of 72 application
Absolutely.
stage. When he is disputing, let us suppose the month or the quantum. So at that stage, yes.
Malad,
We proceed next. The needful has to be done within the time stipulated and actually should accompany. So the proviso only gives liberty to extend the time once by period not exceeding 2 months. You are referring to this.
Lordship.
So beyond 2 months, an adjudicated amount
Cannot be extended.
no extension, once for all.
That is one thing. The second aspect is in this matter, there was a dispute with regard to the quantum of rent also. The quantum was
Let us not go back to that. Now it has been adjudicated. Mr. Banerjee Bandopadhyay cannot challenge that.
Lordship.
Adjudication part is there. So don't go back to that stage.
Very well. But
Because none of you can go back to the earlier.
what I wanted to highlight, Lordship had made a query to me. But even if it is an admitted amount or it is a disputed amount, everything culminates with the order passed.
Yes, yes. Absolutely so. That
Absolutely.
is why I said once an adjudication is made, there cannot dispute goes. Because dispute has been adjudicated upon.
And when that adjudication is complete, but strict adherence has to be
Has
made.
to be made. And you are relying upon proviso gives the leverage to extend once by period not exceeding 2 months.
But that proviso was never asked for to be invoked in the present dispute, which is now before your Lordship.
Because
2 months already over.
Yes, that was done. 72 adjudicated amount
So
was deposited.
they are not agitating that. They are agitating something else. Lordship will kindly see in the previous paragraph, that is paragraph number 15, 16 and 17, all the judgments which Lordships have been, considering all these days, Nasiruddin case,
All have been considered.
all have been considered.
Yes.
And after this, the Supreme Court comes to this finding that there has to be a strict adherence. Now, what they have done? Well, to my submission, the strict adherence that was required, that was not done. The quantum that
What
was
is the violation according to you? Violation of which provision?
violation of, Malad, the rate at which the court
Under
direct,
what provision of this premises?
but 7-2, but in the 7-2,
72 adjudication. 72, what does it say? 72 says with regard to the areas. That has been, you have said that he has deposited that.
not only areas, Malad, the 7-2 order culminate, when an order is passed in 7-2, the 7-1 order does not remain. It culminates with the 7-2 order. Lordship, I will show that judgment also.
Yes.
But the 7-2 order is a final order with regard to the areas of rent,
Has to.
quantum of rent.
For that, you did not cite any decision.
Yes. Malad, at that point of time, the plaintiff, the defendant cannot fall upon what had happened in 7-1.
No, cannot.
Absolutely. Malad, there, the extension part that has been stated to your Lordship, Malad. Malad, here that has not been done. The quantum that was adjudicated, that was violated. He might have given some reasons. And if that violation is made, the law does not provide him any remedy. If there would have been a remedy, if 151 could have been invoked, Malad, I make this submission that there was a concept of BP Khemka's case. Malad, there 151 could have been applied extension of time could have been
Proviso was not there.
absolutely, my lord. Absolutely. The concept of BP
That
Khemka.
shall was interpreted as may.
Yes. Now that interpretation,
17.3, Khemka's judgment.
but that
17.3, that shall was interpreted as may.
but for so many days, my lord, we have given so many reliefs to so many tenants. But that discretion with the court now does not lie. The court becomes basically a functus officio after passing an order of
I
70.
think I do not know whether that paragraph of Nasiruddin has been quoted.
Yes,
Nasiruddin says it's not because the earlier concept was beneficial for the tenants. Nasiruddin made a departure.
absolutely, my lord.
I think whether that paragraph has been quoted in this, no.
Yes, my lord, that has been considered. That has perhaps not
So
been
that
quoted.
paragraph, one of the paragraphs of Nasiruddin says that
My lord, it is in paragraph number 15, perhaps.
it has been quoted.
Not quoted, my lord. I do not exactly remember what was there in that. My lord, here it has been
Alright.
made, it has
Alright.
been stated that the paragraph numbers 37 and 38 of Nasiruddin's matter, it has been made mandatory.
Yes, sir.
That has been quoted.
Yes.
My lord, due to this, the court below did not have the option to exercise 151 powers.
Yes.
Orindam?
Yes. Anything more?
Yes, something more.
Yes.
এইটাতেই ওই বিপি খেমকাটা দিয়েছে না? হ্যাঁ, এটাতে না পরেরটাতে? তো মনে আছে? আচ্ছা।
Yes.
But the same concept that has been laid down in the next judgment is a coordinate based judgment of Justice Ajoy Kumar Mukherjee. But this is also 2024. But the relevant paragraph is paragraph number 10,
Paragraph number
10, 15, 16, 18, and 19.
(17 to 19).
Lordship. I am sorry, 10, 15, 16, 18, and 19.
Yes. Yes.
But the same thing, what is shall, what is may, it has been interpreted
Yes.
here, but in a very lucid manner. And this was also with regard to the area rent, not complied, extension asked for. Here we are dealing with a case where it has been complied, but partly.
According to
complied.
you, there are two aspects. One is adjudication of the quantum, another is direction to pay arrears. In this case, we are with the quantum.
Quantum. Malad, my submission is, it is from me to your lordship, my lord, that even if it is the quantum or it is the,
Yes, I followed.
it is absolutely same,
No power to extend.
no power to extend, and the
Once default
goes. And if the power to extend it is there, then it is totally in contravention of the observations made by the Supreme Court. My lord, now lordship will kindly have a look at these judgments, the judgment of Justice Ajoy Kumar Mukherjee, the paragraphs that I have quoted. Now, my lord, kindly comes to the next judgment. This is a judgment by Justice Savyasati Bhattacharya on the same point. This is not reported. I don't know why.
Which?
But the last judgment that I have given to your lord.
Yes.
But this is CO number 606 of 2018. Lordship has got it. Yes. But para 15 to para 30, that is the relevant part.
Yes.
But in this judgment, Lordship has considered three aspects, three perspectives that has been recorded in paragraph number 17 of
17.
non-compliance. Yes,
Yes.
at running page 7 of the judgment.
Yes.
And may I read it or
Running page 7.
Lordship?
Yes.
But I'm placing it, my lord. The case at hand could be seen from any of the three perspectives. The subsequent default committed by the defendant tenants had no connection with the provisions of Section 7.1 or 7.2 of the 1997 Act and were subsequent defaults after the tenants started complying with the order under Section 7.2. The default was one under 7.2 since the tenants failed to comply with the direction passed under the said provision despite initially having complied with the same, or the tenants initially complied with the direction of 7.2 and went on so complying. The subsequent default could be seen as one under 7.1c of the 1997 Act as an independent default having no connection with the order passed under Section 7.2. But may I try to explain this situation? Here, Lordship considers two situations
Yes.
where a tenant started complying, whether it would be considered as a default under 7.2 or under 7.1c. This Lordship has come to a,
That is the third option.
yes, this my lord has come to a, observation with regard to that. My lord, these paragraphs are very relevant, my lord. I am
That's
placing
the
it.
concluding part of paragraph 19.
Lordship. Lordship reads faster than me, my lord.
Yes. Anything more you want to cite from this?
Yes. Lordship will kindly come to paragraph 24.
24.
Lordship.
Yes. 24.
23.
Last three lines.
20. Yes. Lordship has considered this earlier. No? Very good.
Although started with paragraph 24.
Very good.
Thereafter, you went back to that.
Although Section 7.2 does not contemplate a monthly deposit, but merely the deposit of rents as
This is the submission which you are making. That
absolutely,
once adjudication has been made,
absolutely,
there is no applicability of 7.1c. So everything is under 7.2.
absolutely,
That is paragraph 24.
absolutely.
Yes.
And here, Lordship goes to a finding in paragraph 29.
Yes.
In such view of the matter, even if the default was in respect of a subsequent current deposit, here this is the, the
This is
default.
on the facts of your case.
Absolutely, my lord. And not arrears strictly in terms of subsection 2 of section 7, having chosen to give a go by to the section 1 and invoke subsection 2.
Yes, yes. I've seen that. Anything more?
Section 5 does not apply in any circumstances, but that has been taken care of in the judgment of Chamaria.
In the judgment of Chamaria.
Chamaria, which is my item number 1 in the judgment list. Malad, in Chamaria, the other concept which I have just now tried to explain to your Lordship, my Lord, BP Khemka's case has been considered. If Lordship will kindly come to paragraph number 21.
21.
Yes, of 2019, that is
Yes.
Chamaria's case.
Yes, yes.
But here, their Lordships have also considered that it does not confer the jurisdiction to the court to extend a single day's time, and 7.3 applies.
Yes. Because 17.3, 17.2 provision was a slight different.
But I could not follow, my lord.
17.2 provision
Absolutely,
was a
absolutely.
slight different of the 56 Act.
Yes,
Yes.
but I have tried to place these submissions in a very nutshell in my own humble way in my notes. Lordship will kindly consider that. And if after Mr. Bandopadhyay concludes, Lordship needs me to address on the factual aspect,
Factual, according to you, it's not bona fide.
but they could not establish
Any
before the-
finding on of the court
But
below?
I wanted to show that,
Yes.
my lord.
Show me with regard to the bona fide whether there has been any
No,
finding or
no,
not.
the court has given a finding, but the court has gone to this extent that I have no powers. Court has said that. My lord, kindly take
No,
the,
all right, that is the matter of
but the court has said that. Lordship can,
after holding that whether the court could have.
yes, but
Show me that the court
Yes.
has held that.
yes. My lord, kindly see the factual aspect that has been stated in page number 2 and I'm sorry, my lord.
Yes.
এটা কোনটা রে? My lord, we have given to your lordship, my lord, the order number 141, that is the order impugned. We have also given to your lordship the 7-2 order and the order passed in the civil division proceeding. My lord, their lordship will kindly observe, my lord, the order passed in 7-2, that is page number 76.
I think, Mr. Banerjee, there is no dispute with regard to that. Let us not go into that.
But that part has to be considered by your lordship, where there was an adjudication with regard to the 7-2.
Don't think Mr. Bandopadhyay is disputing that. Otherwise, he would not have said, this is a short deposit, I want permission. Once he accepts that and applies for extension, that means that he cannot question that, or he is not questioning that
But
rate
But
decided.
the tenure was so big that that could not have been said. It was for a period of 57 months and not. Lordship,
Show me
will-
the order which says that court do not have the power to extend.
Lordship, the factual aspect has been taken care of.
Factual aspect, whether there is any finding with regard to the bona fides.
Lordship,
Show me that.
my lord, that is recorded in page number 3, my lord, last paragraph.
Page number 3. Yes. Starts with, I failed to find any malice.
No, my lord. Impugned order, page
Yes,
number 3 of 8, starts with,
Page number 3 of 8.
yes.
Yes.
My lord, starts, the defendant has further averred.
This is the averment.
Yes.
Show me the finding.
But thereafter he says, the judge records, last
Yes.
5 lines,
Yes.
clerk due to fear of getting scolded and losing the job.
All right. So these are the his statements. What is the finding?
Lordship, it is at page number 5 of 8,
5 of 8. Yes.
decision with reasons. It basically starts, but the observations, last 3 lines.
Yes.
Further obligation is imposed by clause C of subsection 1 of section 7 that the tenant has to deposit current rent month by month.
Yes.
But thereafter court records he has deposited 9,742
Yes.
instead of
Lesser
Now,
rate.
next-
942 instead of 972.
next paragraph. Now the question is whether defendant is entitled to get the mercy of the court or whether the defendant is legally permitted to make such a prayer. There is no doubt that the defendant has somehow failed to comply with the order of the court passed in connection with the application made under section 7(1) of the WBPT Act 1997 in its true spirit, because it is evident from the application filed by section 151 of CPC that the defendant has deposit rent for the disputed period in a lesser rate. It is also a settled position of law that there is no such provision to extend the time to deposit pay the admitted areas of
Finding with regard to the bona fides is the last paragraph of that page.
Lordship.
But this court is not oblivious that bona fide.
Absolutely. But previous to that also there is a finding.
So court makes out a distinction of a bona fide mistake, and court is of the view that
It is a bona fide mistake.
bona fide mistake, so this is the finding.
Yes.
So it was considered to be a bona fide mistake, and that could be condoned.
Yes.
That default could be condoned
But
and
court
from
makes,
complying with 7.1. So the court considered it to be a default under 7.1.
but that should have been 7-2. It has been wrongly recorded. It cannot be 7-1, my lord. After adjudication,
Court was conscious 7.2 could not have been extended.
but the court did not take
Court-
into.
Court is of the view, you can kindly come to the previous page. Kindly come to the previous page, page 5 of 8, last
Lordship.
paragraph.
Lordship.
Last 4-5 lines. Here, clause A,
Of subsection 1 of section
yes,
7 of.
casts mandatory duty upon the tenant to pay the admitted areas of rent deposit which is in CSIN. Further obligation is imposed upon C, where the tenant has to deposit current rent month by month.
But
Now,
here
kindly
the court
come
goes
to-
wrong.
kindly come to this, yes. So the court was of the view that it is a default, and under section 7.1, this led to the finding of page 7 of 8, keyword, the tenant has to satisfy which prevented him from complying with the provisions under 7.1. So the court was of the view, so this is non-compliance of 7.1C.
Yes.
7.1C, thereafter, after first, thereafter. So the court's view was that there is no default of 7.2 because the area amount and other things have been paid. Thereafter, compliance is under 7.1C, and there is a default of 7.1C, and if there is a bona fide mistake, that could have been condoned.
But this is what I want to submit before your lordship, my lord. Here the court went wrong. After the 7-2 order is passed, it is an adjudication, and thereafter, my lord, the 7-1
Yes.
order
Anything more?
culminates. Yes, but here the court has made that observation that there is no
According to you,
provision.
this is contrary to the observations of
Contrary to the observation, but the court considers it as bona fide mistake. It is my submission.
that is factual.
Yes.
That is on factual according to you.
My
this is not-
submission, there is no scope now under the amended provisions or the provisions of 1997 Act for having any bona fide mistake or having any default under any circumstances whatsoever. But that has been enunciated in the 3 judgments that I have given to your lordship, my lord. And that situation was exactly the situation which happened in the case before Justice Sabyasachi Bhattacharya.
Anything more?
No.
Yes, Mr. Bandyopadhyay.
I am before a court, my lord, who is better known than me. My lord, I am before a court who is more conversant in this
No, no,
field of law than me. My lord, kindly take the judgment of the Honorable Justice Sabyasachi Bhattacharya with my learned friend.
So you can proceed in your own way. You are starting with the partner. Do you want
Yes,
to?
no, I'll just show that because it's relevant. My lord, kindly
Alright.
take paragraph 4.
Paragraph 4.
Yes, of that judgment. Only one
Yes.
paragraph. No, there was an initial and order. Pursuant to such order, opposite parties went on depositing the amounts as directed therein for some time. However, no deposit was made by the opposite parties for the period from March 15 to 2000 July 15. So factually, my lord, this was a different case. There is no such case that no deposit was made. It was purely an error committed by the clerk, my lord, 972 instead of 942. My lord, findings of the court below is the bona fide mistakes, and that is why, my lord, I would say, my lord, rightly exercise 151 in hand power. And I'll just justify, my lord, kindly take first judgment because he has already, my lord, taken to your lordship, my lord, to the facts, my lord. I do
Yes.
not dispute.
Yes.
My lord, why I am relying this judgment, this is a 2-page judgment. It says the court found this is a substantial compliance, sufficient compliance. So there was no default. The fact more or less same.
No, but the where is the
Provisions were also
provisions.
provisions were
How do you
also.
say that?
My lord, I have checked it. My lord, it was under the old act. my lord, even under the old act of, my lord, 1956 act here also,
1956
Sir,
Act,
there
Mr.
are
Bandyopadhyay,
judgments,
is
my lord.
different because
I'll show,
you
I'll
did
show.
not go to Patna. Khemka's judgment is, a Supreme Court judgment is in your aid.
No,
You
I'm
did
not.
not go to Patna.
Yes, I'm not. I'm
But
just
the
showing
question is,
one line.
whether the similar proviso was there,
Only-
curtailing the right of the court to extend.
No, my lord, kindly take, my lord, paragraph 5.
Paragraph
5 of that judgment. My lord, only I for myself on examination of the factions of the could not feel persuaded to agree with the contention of the landed counsel for the landlord and would hold that the deposit made by the petitioner, which was although short by about 31, was a sufficient compliance of the orders and did not render written statement to be struck off on an applications thereby of default in carrying out the order passed under section 11A. The allegations was the
substantial compliance.
substantial compliance. Well, that is why, and I'll now straight away, my
But
lord,
there is a Supreme Court judgment you will find just after Khemka, maybe in the same
my lord, this
volume
is
or in
not
the
a 7.
or in the next volume.
This is
There
not
was a
se-
default strike for that. For 1 month, there was a default says no. Defense,
that-
I think that was under the
Malad-
Bihar.
Yes,
Act.
Malad, this was 1 month non-payment at all. Here, every month payment was made. There's no default, my lord. Only instead of 972, 942 was
I
paid.
follow your
Yes.
argument that
kindly
it's a
take-
substantial
My lord,
compliance.
kindly
It's
take
not a
it
case
goes
of-
ultimately against me, my lord, AIR 1973 Calcutta in respect of, my lord, power, my lord, in a tenancy matter under 151. Your lordship must have gone through it, my lord. The second judgment, my lord, I'll be referring to paragraph 16, 17, 18, and 19.
This is against you.
Ultimate conclusions.
Yes.
But in the court had, my lord, came to my support, my lord, in kindly take.
No, but this was considering the 56 Act. Now
I'm
the
not, my lord,
question,
even under 56 Act, court held, my lord, your lordship was aware that 72 cannot be extended.
yes,
Even under 56 Act. My lord, there was conflicting judgments on this 71 and 72. My-
this
why
proviso
I'm-
was not there.
Yes, why kindly take, my lord? If your lordship,
Paragraph
16, 17, 18, and 19, your
16
lordship,
to 19.
yes, my lord, kindly skip 16 and 17, discuss, my lord, 151.
Yes.
My lord, I'll just, the earlier judgments have been discussed, my lord. It will thus appear that the court has recognized relaxations in regard to
Which
the
paragraph you are placing?
18. Answer.
Yes.
Because earlier two paragraphs,
yes.
the judgments considered. It will thus appear that the court has recognized relaxations in regard to the provisions of statute which even may be mandatory in circumstances mentioned above. The court has also granted reliefs in such cases even though the other party has been thereby deprived of a benefit or right under the mandatory provisions of law. The question that calls for attention is whether there is scope for further relaxations to the provisions of the statute and of a court's order passed on the basis thereof in the context of the present day existence.
It will be on 19. It will be, however, before the
Yes,
defaulting party on
yes.
the facts of
I'm
this
only
case to
marked.
establish.
Only on 19.
Yes, 19. I've seen that.
I'm
Yes.
only 19. Malad, 18 had been, I was reading only to show 19.
Yes.
Now kindly then Well, 79(1) SCC, I took Malad only to show that the Supreme Court, the three judges bench consider section 39 of the limitations would be applicable, which has not been Malad looked into in 2019, but I am not asking your lordships to go into these disputes. Malad, even I have cited 2015 8
I
SCC.
think there was a reference or any decision of a coordinate bench on
Yes, I am not.
consideration of section 41 of the Limitation Act.
Yes.
For 41 of this Premises Tenancy
1970
Act.
to 1997 Act. My lord, and the Honorable Justice Shampa Sarkar has the last judgment. My lord, the division bench simply holds since this is Vijay Kumar Singh's judgment is there, we are bound under 141. That is the last judgment I relied. But Vijay Kumar Singh was relating to my lord 7-2.
Yes. So
Now, I will
in
be
this you are relying on paragraph 6. 79(1) SCC, you are relying on paragraph 6.
Yes, and Gopal Shaw, my lord, I like to show, my lord, that is
Gopal
88 1 CHN
Yes, yes.
31. It's factually slightly different. But kindly
For what
take
proposition?
paragraph 2, that when the
Yes.
court can, my lord, condone. Facts are slightly different. The technicalities, my lord, has been overlooked.
Yes.
And a senior SP Rai Chaudhary, my lord, stress
So you are on the negligence of a lawyer, the party should not be penalized.
party should not be penalized. And there is a bona fide mistake. My case is there was no default. There was no default at all.
So this will be on facts. If you can succeed on the law point, then on facts according to you,
There
so
was
you
no
could not be
default.
penalized for
My lord,
the.
the 7172 will be applicable where there is a default. My lord, my submission is there was no intentional or default at any point of time. 72 complied with all
You could
areas
not be
deposited.
penalized for the laches of the clerk.
And since there was no default of a single month, because
Yes, yes.
Honorable Justice Shobhos Bhattacharya, your lordship has seen 4 months complete default.
Yes.
The other judgment is 1 month complete default. But here there was no default at all. And they did not point it out. They did not file any applications under 7.3, my lord, prior to my applications. It is me who detected it and filed. And in fact, all deposits have been made as soon as the court directed. So all these judgments are distinguishable.
Yes.
And the court had power, my lord, to exercise 151.
Yes.
So this is my submission, sir.
No, the other judgments. you want
Other
to-
judgments, my lord, I just these are 2019. My learned friend had already shown.
No, 2015-8 you have.
Yes, 2015-8, my lord, goes contrary to Bijay Singh. It says limitations. It's condoned, my lord, 2015-8.
And Justice Sharka's judgment you.
This is, my lord, following 2019. Kindly, I just show this, my lord. 2015 to, my lord, I must show.
2015-8.
8 SCC, my lord, paragraphs 22, 23, 25, 26, and 27.
22, 23,
20.
25, 26, 27.
Yes, I have marked, I've given the relevant. It should not be pages, it should be paragraphs, my lord. Probably my junior said.
No, paragraph.
Yes.
Yes. Oh, you have mentioned these paragraphs at the top.
Yes, it
All
was
right.
mentioned as pages.
No, no, yes.
I'm wrong, my lord.
It should be paragraphs. All these are paragraphs.
Yes.
Yes.
Kindly take paragraph 22. There was a default. My lord, default in true sense. It is worth to mention here that as against the finding of the trial court, that since the respondent tenant deposited the rent with rent controller instead of depositing in the court, the respondent tenant became defaulter as contemplated under section 7(1) of the Act. The tenant filed the review petitions under section 151. The said application was rejected and the revision petition filed against the said order was also dismissed by the order dated such and such. The respondent then moved this court against the order dated 14th by filing a special. The said special petition was taken up on 29th July 2013 and was dismissed with the observation that it would be open to the SLP petitioner to raise all questions before the court as to whether alleged default is bona fide. The order dated 29th July 2013 passed by this court is quoted below. We see no ground to entertain this special petition. However, we leave it open to the petitioner to raise all questions before the trial is pending, including the default alleged against him, so as to consider whether the same can be treated as bona fide in order to satisfy the conditions laid down under section 7 of the West Bengal Premises Tenancy Act. Then, as discussed above, the instant appeal by special is against the orders passed by sentences passed by rejecting the review petitions filed by the appellant landlord, holding that the respondent was complied with the order passed on the application. In the background of all these facts and the sequence of the orders passed by the small cause court to this court, we have carefully analyzed the decision. Indisputedly, rent control acts have been enacted in different states with the object to protect the tenants from illegal eviction without obtaining the decree or order from competent court on one or more grounds provided. At the same time, it is well settled that the benefits conferred on the tenants through those rent control acts can be enjoyed only after strict compliance with the statutory provisions. Mr. Rao, learned senior counsel appearing for the appellant.
This was factually different. This was when this was amended from rent controller to civil judge, deposits made before the rent controller may not have been aware of.
Yes, Malad, that is I factually, I just wanted to show that the Supreme
Bona
Court-
fide part.
that was accepted by the court.
Yes.
Malad, these are my other two judgments. I just bring you losses to the notice because these are the judgments, and last judgment is kindly take last judgment, this special bench, although it is division bench. The Malad Amit Kumar Chamaria, now the concluding.
Last judgment means,
Justice Shampa Sarkar.
yes.
Now kindly take,
This is a special bench judgment
this is a special bench on reference.
on reference. What was the reference?
The reference was Malad, because of two single judges bench judgment. Contrary, Malad, kindly take Malad, page the civil revision application first paragraph from the circuit bench at Dalpaguri have been referred to this bench at the principal seat of Calcutta in view of the divergent opinions of two learned single judges of this court. The moot question involved in the application whether the court can extend the time for depositing the admitted area rent together with statutory, again under Mala 7.2 after adjudication.
So question number, reference point number D, how it has been answered? B has been answered in
Yes,
which paragraph?
Malad, last Malad paragraph.
21.
Malad, first Malad, from 22, Malad, kindly take Malad.
22, yes.
Section 40 was considered. Section 40 of the State Act makes the Limitations Act applicable to the provision subject to other civil principles of limitation. The Honorable Apex Court discussed the provisions of law held that section value would not be applied. Malad, this Honorable Apex Court means Vijay Kumar Singh, 2019. According to the ratio in Amit Kumar Chamaria, the period of 1 month and mentioned in paragraph 7.1b was stated to be inbuilt period of limitation, making section 40 of the State Act inapplicable. Thus, the decision in Bahadur Katotia cannot be accepted as good law. The decision was rendered without considering paragraph 19 or
So paragraph 24 is the ultimate answer.
ultimately, Malad simply said the law was declared by the Apex Court and it was duty of the High Court to act in accordance with 141 of the Constitution and to apply the same.
But this is the division bench judgment. I am bound by this.
Malad, that also relates to Malad 7.2 Malad at the initial stage, the determination of the area and the payment.
But now the division bench has given a
Malad,
finding on that.
simply followed Vijay Kumar Singh. I said, Malad, here there is no question of default, no question of 7.2. Malad, is simply bona fide mistakes which has been corrected by exercise of inherent power under 151. That court has ample power. I rely on this 73 Calcutta judgment, Malad, paragraph 19. It's a pure bona fide mistakes. There was no intention. There was no default at all.
Bona fide is 73 Calcutta.
73 Calcutta, Malad. 73 Calcutta, Malad, Sitola Devi, division bench judgment.
This is on bona fide mistake.
Bona fide mistake, Malad, one judgment. The first is Malad, Patna is substantial compliance.
And another bona fide mistake is of the Supreme Court in that
Yes, Malad, in 2015 8 SCC.
1586. That was also bona fide.
Bona fide mistake.
So
And
that was after the amendment of
after
the
amendment.
rent controller with the civil judge.
Yes, after the
Deposits made before the rent controller.
Yes. That is a bona fide mistake. Even after amendment, they went on Malad, to go on depositing rent controller. But here also there was no default. 972 was read as 942. Malad, it's a regular mistakes committed anybody. Regular mistakes. And the clerk, Malad, and that was, I would have accepted my learned submissions if there was a default of 1 month, if there was a default of 3 months, just like the Honorable Justice Shobhushaji Bhattacharya considered case, paragraph 4. Malad, here there was no default. I say there was no default at all. Malad, no question of extension or Malad, applying 7.2 or 7.3 doesn't arise. There's no default. Only it's in reading in the provisions, Malad, it cannot be said the short deposit is a default, Malad, within the Malad premises of section 7. There was no default. It was detected by the petition, by the tenant.
Define this expression default.
Default, Malad,
Is non-payment only or short payment also?
Malad, I have not find Malad anything Malad on short payment has been treated to be default. Or if my learned friend has found, I have searched a lot. Only judgment I got this Patta judgment which says insufficient compliance. Non-payment means non-payment. My lord, the provisions also says non-payment. It doesn't say that non-payment of full amount. Even that also is not there.
No, but it says at the rate,
At the rate specified. I said it was, in fact, my lord, initial 3 months at the rate specified. Then this mistake occurred.
the amount referred to in subsection 1 or subsection 2.
My lord, it
So
is
amount is the rate.
subsection 1 and section 2. This is the
And
adjudicated
subsection 2.
rate. But
So
the shortfall,
if there is no default subsection 1,
yes.
no, if there is no dispute subsection 1,
Subsection 1, if
there
there
is
is
a
dispute,
dispute, subsection
subsection 2. There is no dispute. That is why, my lord, the code below also taken it to be under sub 7.1. Because after the adjudication, there was no dispute. I was paying.
no, that is the whether after, because 7.1 deals with a no dispute situation.
Yes.
7.1 is a
Alright,
no dispute situation.
Yes. I was just referring the judgment of the code below. My lord, this is, if this be not.
7.1 is a no dispute situation.
Yes.
Because if you find on a suit being instituted, shall pay to the landlord all
My lord,
areas
kindly
of
take
rent.
7.1c.
No, first you have to first see 7.1a.
Yes.
A says, because that is the initiation.
Yeah, that is no dispute.
Shall pay to the landlord or deposit all areas of rent calculated at the rate at which it was last paid and up to the month previous to that, such and such. Such
Then-
payment or deposit shall be made. This is the time limit.
That is the time limit.
Next, C.
No, no,
Shall
that-
thereafter continue to pay to the landlord or deposit each a sum equivalent to the rent at that rate. So,
Yeah.
after you have been served with a summons, so you have to comply with 7.1a for the first month. Within that time, thereafter
7.1
continue to deposit.
7.1c.
Let us assume there is no dispute with regard to anything. You accept, yes, this is the rate, this is the default, I have defaulted, I am depositing the entire areas. So there is no necessity on your part to file 7.2. Now, if in any suit referred to, there is any dispute as to the amount of rent, then comes 7.2. So once a dispute has been raised,
I have not.
so now 7.1 goes.
Yes.
Now it's a 7.2.
Now-
7.2 has two parts. One is with regard to the adjudication of the areas, deciding the quantum of rent, and you have to comply with the subsequent. Now, the question remains, after adjudication, the subsequent deposits, whether it is to be under 7.1 or it's 7.2. 7.1 is a no dispute situation. So once a dispute was raised and adjudicated, whether you can now fall upon 7.1.
Then, my lord, 7.2, if it is 7.2,
Because there are two distinct stages. One is no dispute situation, another is a dispute. No dispute 7.1. Once a dispute 7.2. And even then, till it is decided, you have to comply with 7.1.
kindly take my lord 7.3 once.
Yes.
7.3, kindly.
7.3 deals with both.
Both. My lord, kindly-
One or two.
Yeah, one.
So
Now, kindly take just, if the tenant fails to deposit or pay any amount referred to.
yes,
So, in subsection 1 or subsection 2, within the time specified therein, or within such extended time as may be granted, the civil judge order defense to be strike out. So, even if, my lord, a strict sense, my lord, it is when there is no deposit at all, 7.3. Then time fixed or such extended
no
time.
deposit default may be also there.
Default, my lord, default.
So you are trying to make out a case that once you deposit the areas as directed, then you have to fall back on 7.1c. That is your argument. That I have to consider.
And if,
Whether after,
my lord, if this default is not, my lord, is not cured by a court, my lord, under section 151 of this, my lord, mistake in the, my lord, deposit at the instance of the clerk, when there was no intentional laches on the part of the tenant, my lord, that my lord, even if, my lord, as a court of equity, my lord, cannot, my lord, be denied. That strict applications of the provisions of 7.1 show even not contemplated by the Honorable Supreme Court. This will create an anarchy. Because it may be, ₹1 less, they will come up with the defensive strikeout. This is absurd. Even 972 includes corporation tax.
No, whatever. Now we cannot
I'm
say
not, I'm not.
corporation,
That is-
DPS.
No. So
10%.
there was no.
Now it's the consolidated rate.
Yes. Now there is no dispute, nothing. There was no intentional default, a short amount, less amount at the instance of the clerk.
There are two things. What you are trying to submit is bona fide, no intention, unintentional.
And
This
whether
will-
in
this
such
will-
a
this will
situation,
come into play once the court has the power.
yes,
If the court has the power, then it's not mechanical. Even if the court has the power, bona fides can be looked into. It's not an automatic. Court has the power, condonation also. Section 5, even if it applies,
Your Lordship has held, my lord, in Order 6, Rule 7 amendment applications, even after trial, there was a clerical mistakes that can be corrected.
that is a
Even if that bar is
bona
now,
fides,
new bar has come.
even if the court has the power, even in Section 5 of the Limitation Act, even though you cannot straight away condone that,
Yes.
though the court has the power, so bona fides or the grounds can be looked into.
Yeah.
So that will come once the court has the power to condone.
Yes, I said, my lord, it will again fall, then again.
7(1)(c).
7(1)(c), so the court had power. And this strict compliance was not contemplated by any of the judgments, because this is not a case where a complete default has been made. That aspect should be looked into. Otherwise, it will give rise
Anything
to
in
many
reply,
litigations.
Mr. Banerjee?
My lord will only consider Justice Sabyasachi Bhattacharya's judgment, paragraph number 19. Page 8 of the judgment, paragraph number 19.
Yes.
After the passing of the 17.7.2 order, the question of 7.1 compliance, 7.1c compliance is unheard of.
That is because has to be, because these are
Has
two.
to.
These
Has
are the two applies in two different spheres. One
Absolutely.
is the no dispute situation, another is the dispute situation.
What has fallen?
Even if there is no dispute, that is why 7(3) uses the expression subsection 1 or subsection 2.
But I'm showing that. I'm showing that.
What?
What is the 7.3?
7(3), for that, let us assume there is a no dispute
Hmm.
situation. So the question of compliance of 7(2) does not happen. It's only 7(1)
Yes.
all throughout. So then if there is a non-compliance of that, then also 7(3). And after adjudication, if there is a dispute after adjudication, if non-compliance, then also 7(3).
But I want to read with your lordship 7.3 once. But prior to that, lordship will kindly consider the judgment that my learned other side has just now cited.
Yes.
That is that 2000,
It only permit me.
Yes.
2015 volume 8 Supreme Court cases.
Yes.
But that has been referred in the Chamaria judgment,
2015.
volume 8 SCC. That is a situation before the rain controller, rain control deposit, and that has also been taken into account in the judgment passed by the Supreme Court in Chamaria. In Chamaria's judgment, page 666,
This was considered in, what is the reference of in Chamaria's case?
Chamaria's case is 2019 volume 10 SCC,
Yes.
page 660.
That is in your compilation.
Yes, in my compilation and their compilation also.
Yes.
Malad, in this, at page number 666, Lordship will kindly come to my
Yes.
write-up.
Yes,
Malad,
paragraph 9.
Lord, no, before that, my lord.
So paragraph 9, this was Octavius was considered.
Absolutely. Judgment referred is judgment number 10.
Yes.
But this was considered and thereafter it was rejected, or the conception raised therein was not considered. So that
So
has
this
been,
was considered.
yes,
Where is the finding that it does not lay down the law or
but
distinguish?
that is not there. That is not there. But this was considered and the principles laid down in that judgment was not upheld by the Supreme Court.
That is on a different point.
That is
Because
on-
that's amendment might not have been known, and this factually it's distinguishable.
But this is what prompted me to point out to your Lordship, my lord, that this judgment has already been considered.
But whether any finding on that,
No. I've read
the
the
effect of that, Mr. Banerjee,
but the
only
effect,
referring to an earlier judgment, but not.
why I state before your Lordship, my lord, this judgment was cited by the party
Yes,
who was trying to claim relief under this provision,
yes.
but that relief was not granted. That relief was not granted by the Supreme Court. On the contrary, an absolute different relief was, granted by the Supreme Court, where the absolute different point was upheld. This is my contention before your Lordship.
Because these two are the coordinate bench.
Yes.
So what is the effect of no
But
finding?
in words, it has not been discarded, it has not been said to be bad law. But still, the
It has
observation.
also not been distinguished on facts.
Yes, absolutely.
Distinguished.
No, it was not. But the principles laid down in the judgment was not taken into effect. And this is a subsequent judgment. And this subsequent judgment was again upheld.
According to you, per incuriam theory may not
Absolutely.
apply. Because it was not in ignorance of that earlier judgment.
Yes, it has been duly considered.
Considered and not, that principle not applied.
But
Or a different.
the last judgment lays down the law that is to be followed by the courts. Now, my lord, the 2024 judgment is also on the same count. 2024 judgment that I have cited before your Lordship, my lord, strict compliance in all aspects. But that also upholds this Chamariya case.
Yes.
That has to be considered by your Lordship, my lord. Now, the other aspect, but kindly permit me to read section 7.3 along with your Lordship.
Yes. মেনশন হয়েছিল
শুরু করতে বল, আর 5 মিনিটে চলে গেছে, শুরু করতে বল। Lordship will kindly consider subsection 3 of section 7.
Yes.
If the tenant fails to deposit or pay the amount referred to in subsection 1 or subsection 2 within the specified time therein or within such extended time as may be granted, the civil judge shall order the defense against delivery of possession to be struck out and shall proceed with the hearing of the suit. But it also takes into account the amount that was specified in subsection 2. But they have not complied to that, whatever reason be there.
Only one clarification.
Much.
7.3, the expressions or within the extended time
Yes,
as may be granted,
yes.
it refers to 7.1
No,
or 7.2.
but 7.
What is the effect of this disjunctive word or?
But
What is the
here,
effect of this?
but here in this case, it,
No, not in this case.
but in all cases, in all cases where there is
assume there is a no dispute situation
absolutely
and there is a default in 7.1 because then 7.2 does not come into play.
but I'm trying to explain.
There is no, let me give you the question first, otherwise you cannot explain. It's a no dispute. Let us take a no dispute situation. Rate, default, everything admitted. So tenant deposits the defaulted amount initially, thereafter goes on depositing. There is a default of 1 month. What is the effect of that? Whether the court has the power to extend,
Yes,
has the power to extend under, I'm asking you, if the court has the power to extend, under what provision?
yes. But when a 7.1 order is passed, a party has, there is no 7.2 admitted situation, there is no 7.
No 7.
No 7.2. doesn't file any 7-2.
Because there is a no dispute situation.
From
Let
the-
us assume there is a no.
From the date of the order, at the most it will be 2 months extension.
Where do you find that?
Malat, in this only,
That is 7-2.
in 7-1 also.
Show me that.
Yes.
Proviso is with 7-2 or 7-1 also. Because this proviso is with
But for a
7-2,
but for a moment,
not 7-1.
but in 7-2, the proviso is there.
Yes, not in 7-1.
Malat, that proviso also applies in 7-1. It never, Malat,
Where from do you say
Malat,
that?
it never says at any instance
Mr.
that,
Banerjee, are you suggesting this proviso has to be read into section 7-1?
but certainly, my lord,
How?
but
This is a
certainly,
proviso to section 7-2. Cannot be 7-1. How
Malat,
do you say? This is a proviso to section
but
7-1.
even that be so. Even that be so.
So I'm asking you.
Yes.
So in a no dispute
But
situation,
it is my contention before your lordship that these two sections, 7-1 has a 7-1 A, B, and C, and 7-2 has no A, B, and C. It is only 7-2. In this
how do you say so?
7-1
7-1 and 7-2 are distinct.
are distinct.
One is no dispute
Yes.
situation, another is a dispute situation.
Yes.
So proviso is applicable to 7-1 and 2 both, or 7-2.
But this proviso is applicable to both 7-1 and 7-2.
No,
But
it does not say, Mr. Banerjee, it only qualifies 7-2.
But even if I accept that, but even if I accept such a situation,
Yes.
even if I accept such a situation, after the adjudication in this case,
That is a different thing also.
yes,
No,
then 7-1C does not,
there are two aspects. Mr. Bandopadhyay's submission is that I will have to consider.
yes,
If it is a non-compliance of 7-1C, that is why I am asking you.
but
Whether this
that,
proviso is,
but that observation has been given in paragraph number 19.
Mr. Banerjee, you have submitted that.
Yes,
But Mr. Bandopadhyay is
I
like,
can-
I will have to consider
but
that.
that will be the ideal situation. All lawyers would have been happy if that contention would have been
That is why I am
appreciated.
asking you.
Yes.
That is why I am asking you. what
But
is the
I, as a
interpretation of
lawyer,
this
I
proviso?
go with Mr. Bandopadhyay.
No, not that. With regard to an officer of the court, I'm asking you a point of law. Whether this proviso is 7-1, 7-2 both or 7-2.
Malat, kindly see, here the
Subject to
proviso,
correction, it cannot be read into
Malat,
7-1.
kindly, Malat. But why I say it goes with 7-1 also, but 7-1 specifies a time period within which you have to make deposit. 7-2 also gives a specific time period within which you have to make the deposit. What is the default?
Do you have any decision on this? Proviso will apply.
But this
to
is
7-1.
what I perceive.
No, no. You
But I
any-
have to look into it. I have to look into it.
anything more, Mr. Banerjee?
No, my lord. Only one more thing, my lord.
Yes.
But this to me applies to both. The last situation that I can tell you, Lord. But the time period, Lordship will kindly consider.
According to you, it is 7-2. So we need not go to 7-1C. This is not necessary.
And even if in an ideal situation, if there is non-compliance of 7-1, in that case, 7-1 also specifies the time period. And this proviso states,
There are two things why I put you this question. 7-1, 7-2, there is a specific embargo.
yes,
After 2, there is no question of extension. So whether there is any specific embargo so as 7-1 is concerned, or that can be
but
extended.
the wordings are such, but it would be my perception, my lord, this proviso is applicable to both.
All right. Yes, Ashun.
Only one more thing, my lord. But kindly visualize a situation, a party being directed to pay 10 rupee per month as the monthly rent. But if in a situation where my learned other side is, if this is appreciated, everybody would come. I could not do this
No, that is not
within
there is
such
al-
time period.
আসুন,
and that has to be extended.
heard the learned advocate for the parties. Hearing concluded, judgment stands reserved.
My notes of arguments we have submitted.
The notes of arguments filed by the short notes of argument filed by the petitioner and the compilation of judgments filed by the learned advocate for the opposite party are taken on record.
Do I need to stitch it, my lord, or it would suffice?
Stitch it, otherwise if that ওটা দিয়ে দিন stitch করে দিয়ে
Perhaps Lordship has not marked anything there. Perhaps Lordship has not marked any portion there, then I can give my thought. I'll share it. I'm stitch.
marked. No, I think something I have
Yes,
marked.
yes.
Those paragraphs and other
আমরা
things
সেলাই
I have
করে
marked. I have a division bench at 2. After that, I will be coming. Now I have a division bench at 1. So the single bench will not continue till 1:15. I have a division bench now.
দুটোর সময় যাচ্ছে
2 p.m. also I have another division bench. If that division bench is completed, I will come.
তো লোক কোথায়?
Yes. 30th March 2023, my lord. Under the, it is a memo. Memo na appeal.
After passing the order, they are always threatening me regularly. Thereafter, the another complaint has been lodged, Joseph.
Yes, and yes, what is the, what
Yes.
you are saying, the civil proceedings?
Yes, my lord. Only take up, my lord. My lord, in nutshell, I say, my lord, I filed a preemption application on the ground of co-sharership. My lord, trial court hold that since the entire share of the co-sharer has
The stranger purchaser.
yes, stranger purchaser.
What happened to you?
Please. He is stranger purchaser, my lord.
You have filed an application.
Preemption.
Yes, what
Preemption.
happened to that?
Trial court, my lord, dismissed this application on the ground holding that the entire share has been sold. He has
So your preemption application was
dismissed.
dismissed.
Appeal court, my lord, hold following our judgment that the co-sharer, even the whole share being sold from the out of total land, preemption application is maintainable. But it was dismissed on the ground short deposit.
It is dismissal. Why are you going to that?
Co-sharer, undisputed co-sharer.
What different thing is that? So you could not succeed on the preemption application. He is now your co-sharer.
Co-sharer.
What is the next dispute?
And my lord, we preferred,
construction.
my lord, we preferred, my lord, civil division application. Initially, stay was granted, that is pending for adjudication.
Yes.
And now, my lord, this application has been, writ petition has been filed by the wife of the preemptee, my lord. Before the, we are preemptor, we filed preemption application.
Why PMT died?
No. Saying that, my lord,
who wants to make a construction?
Now the lady, wife of the preemptee, who the stranger purchaser.
You are a party in this writ petition. You are a party in the writ petition. Why did not contest the writ petition?
My lord, perhaps, my lord, I do not know, my lord. Copy pass me. We have no instruction to that respect, my lord. Because, my lord,
why you did not contest this?
Perhaps in one day, my lord, this order has been passed, my lord. Perhaps someone have been briefed. Perhaps it has not been.
Have you said anything with regard to that?
No, my lord. My lord, when the police came to us, we preferred this appeal, my lord.
No, you are aware of these proceedings. You are served with a copy of the writ petition. So thereafter, you are aware of this order. So you filed the appeal. When did you file this appeal?
My lord, my lord, on
21st of December 2023.
Yes, my lord.
You have filed an application under Section 5.
Yes, my lord. Section 5 to there. My lord, para 2, my lord. On 19th December, police came and said, my lord,
was the copy of the writ petition served upon them?
Yes.
Evidence service
has already been filed before the learned single bench, the honorable single bench.
Even you have got the copy of the writ petition at that point of time.
We will not take out the writ petition from Sarthak. I am told, my lord. Sarthak website, that is scan copy of.
Show us your statement in the Section 5 with regard to that.
My lord,
when you obtained the copy from Sarthak.
That has not been, my lord, stated, but in para 2, he said, my lord, from this, my lord, we came to knowledge about this.
Have you said that this writ petition was not served upon you? What is the stage of construction?
Preliminary stage, the construction has been started, Melody. They have the thrown, Melody. We have decided to construct, Melody, before Indira Bhajan, the house are constructed at the Indira Bhajan, Melody. But they thrown, Melody, building matters to the nearest pond.
These are all allegations.
Unable to construct the residential house, Melody. My husband is a 96% handicapped, Melody. I'm the lady, Melody, only.
Record is Doba, my lord. Still that record is Doba.
No, but
feeling, my lord, these things are going on, my lord. by the order impugned and order passed in the contempt.
Lordship also directed to take custody of the private respondent, my lord. But the Lord, contempt order, my lord, the page 2, my lord, the para 7, my lord.
Contempt application.
Order, my lord, contempt order, my lord.
Contempt order is dated
Contempt order is
Contempt
dated
order,
23, February,
23/2/2024. Yes,
para 7, my lord.
but this is not under challenge.
No, my lord, because
23rd
we are not,
February is not under challenge.
because my lord, if my lord interferes with the impugned order, it, my lord, automatically, my lord, I presume, my lord.
Have you served a copy of the section 5?
Yes, yes, I have served everything. Everything served, my lord. করে দিস তো? বিশ্বাস হয় না আজকাল তুই যে বলে দিচ্ছিস
Yes, how long you will take to construct?
15 days, my lord.
15 days. So wait for a day. We are keeping it on Monday.
Can kindly give specific direction about the police.
This matter was mentioned at the first sitting of the court, stating that pursuant to an order dated 23/2/2024, passed in CPAN 146 of 2024, the two constables of Panchkura police station has been deployed. First up, considering the urgency, this matter was directed to be listed, and the learned advocate of the petitioner was also directed to serve a notice upon the learned advocates for the respective parties. First up, paragraph. When this matter is taken up, the learned advocate for the state as well as the private respondent is present. First up, today the police was posted.
Today police was.
Only today.
It starts from today.
Start from today.
All right. So you came to know today morning.
Yesterday, my lord, police personnel came and my lord said.
So you came to know about this order when? 23rd February?
Order, yes, my lord. This contempt order.
Yes.
Yes, yesterday police came and said, my lord, this about this order.
Don't come into the area.
Don't come into the area, my lord. If you come, my lord, you will be arrested. Some civic volunteer maybe. না এখন না কালকে সিভিক গিয়ে এখন তো সিভিক দেশ চালাচ্ছে।
But you have not challenged this order.
The contempt order.
Yes.
If my lord stays the my lord impugned order.
How can we stay the impugned order in that? Section 5 is pending. You have served them today. Section 5.
My lord allows the section 5 and my lord subject to my subject. Always subject to. Section 5, my lord. If my lord allows my lord and my lord interferes with the impugned order, it will automatically.
Section 5, are you opposing?
Yes, my lord, I am opposing, my lord. Only they have filed, my lord, the MAT application. They have not obtained any stay order from this honorable court, my lord, the division, my lord. Matter since long pending, my lord. And contempt proceedings has already been started, my lord.
First up, the learned advocate appearing for the private respondent, who is the applicant in the contempt application, submits that since the petitioner contempt application, he is a party, no.
Contempt is not party.
Uh, since the order was not complied with by the police authorities, CPN 146 of 2024 was taken out. First up, the appellant claims to have come to know of this order dated 23rd February 2024 in CPAN 146 of 2024 only yesterday, that is 29th of
29th.
February 2024, when the police authorities came to their residence and informed them.
Civic police.
Police authority.
Yes.
The the police authorities came to the residence of the appellants and informed them about this order. First up, the learned advocate appearing for the applicant in CPAN submits CPAN na kore in the contempt application submits that the appellant has not been impleaded as a party in the contempt application. First up, it is not in dispute that a preemption proceeding was dismissed by the Learned Court of Appeal below, and a civil revision application being CO blank is pending before this court. First up, the private respondents herein claims to have purchased a portion of the property which is the subject matter of dispute between the private parties in this appeal. First up,
My lord, husband of the private respondent.
private respondent is not a party. The PMT is not a party in the writ petition.
No.
Between the
দেখে বল বাবা।
তাহলে private parties না করে
বলে দিচ্ছি।
between the appellant herein
Yes.
and the husband of the how many private? There are many private respondents I find, and the husband of the
Writ petitioner.
writ petitioner is only one,
One.
and the husband of the writ petitioner is which respondent? Here, private respondent,
এখানে রিটে এখানে four.
and the
In appeal
কি
four.
বললাম?
একে
এ হচ্ছে আমাদেরই মধ্যে একজন
The husband of the respondent number
আমাদেরই মধ্যে
4 in this appeal,
নাকি সবাই ফাইল করেছে।
না,
and
একটা
considering the fact
সবাই sign করে।
that and considering that, and since it has been submitted by the learned advocate for the respondent number 4 herein, that the construction has only started today and it will take some time to complete. This court is of the considered view that
পার্টিশন স্যুট এটা পার্টিশন স্যুট এটা কই এটা দেন
an interim order for a limited period is to be passed. First up,
ফাইল করেছি
কবে
27 ফাইল
the considering the urgency of the considering the urgency, this court is inclined to pass an interim order in spite of the fact that the application under Section 5 of the Limitation Act is application filed বলেছি তো, filed under section in connection with MAT
কমিটি নাম্বারটা বল না।
518.
251
2518 of 2023 is pending, treating this case as an exceptional case. Full stop. The respondent number 4 is restrained from making any further construction in the property being, where is the schedule of the property? Tag number, anything?
C2 কোথায় আছে?
Plot 324.
In the writ petition you have stated,
Yes, yes.
Plot
they have
number?
stated.
Yes, plot 324.
Representative-
324.
Yes, my lord. But it is page 29, my lord, of the stay application, para 4.
page 29.
Para 4. Application, my lord. In application.
Yes.
Para 4. এটা তো
হ্যাঁ হ্যাঁ হ্যাঁ
আরএস করতে না
এলার দাগ নাম্বার 324
324
কি বললাম?
এলার দাগ নাম্বার 324
এলার দাগ নাম্বার 324 under police station Panchkura,
মৌজা my lord গোপাল হাজরা
within Mouja Gopal Hajra, measuring an area of about 4 decimals out of 14.5 decimals till 8th of March 2024 or until further orders, whichever is earlier. এই ম্যাটার কবে হবে? সোমবার?
8 category কন্টেইনমেন্টটা কি আছে?
সোমবারের পরে? সোমবার আর বুধবার?
বুধবার
বুধ শুক্র তো?
বুধবার
List this matter
বুধবার
under the heading under the heading for admission on March 4, 2024.
can it be on 6 my lord
Stop.
হয় না শুনছিস না নাকি
Let this order be communicated to the concerned, which police station? To the Panchkura police station forthwith. Yes, you inform them. You do not make any construction. You also ask your client. So we are keeping it on. You have served them the copies of the
yes everything
section 5.
yes everything
They have only preferred MAT, nothing else, my lord. In earlier occasion, my lord, they have only preferred MAT application,
Which application?
MAT, my lord.
Yes, yes. No, section 5 he has filed.
Long delay, my lord. Long delay.
That you contest. We have not condoned the delay.
Long
We have only given an interim protection considering these exceptional facts. It can be we contest on the section 5.
yes
You can file your objections on that date. If you have, you can come ready with the
my lord
section 5.
may I pay one that's my lord can it be on 6th my lord Monday my lord Monday my lord I will be
No. Exceptional, we have
yes,
said,
absolute.
we have without allowing section 5, we have
My lord,
passed
yes,
this
I
order.
understand my lord that is
That
my
is
lord,
why we have kept it on
my
Monday.
lord, if my lord Monday my lord kindly accommodate for Passover something my lord
Junior will be
yes
here.
yes my lord.
Passover is a different thing. Your junior will
That
be
is-
here
for me, my lord.
because
yes my lord I
and
understand
also
I
mention
understand
this did not
no
take
my lord
any-
I understand
Sir, this
Only
is very
because,
painful,
my
my
lord,
lord. I'm only lady, my lord. My handicap, my husband is 96% handicapped, my lord. my lord, I am unable to construct my
Wait till Monday since
which is
this-
allowed, my lord, on the Indira Awas Yojana, my lord. I am very poor lady, my
that
lord.
is why we have fixed the shortest possible time. Since today the regular bench is not here,
My lord.
this has happened. We have fixed it on the next available date, that is on Monday.
The interim stay, my lord, this is very
We have made it until further, whichever is earlier. So if it is decided on 4th, it will be on 4th.
Yes.
But unless in the event, for some reasons, it is not, could not be taken up.
poor lady, my lord. My husband is 96% handicapped, my lord.
আচ্ছা ওইটাকে একটা
Only, my lord, the
একটা
residential
সাবমিশন
house, my
রেকর্ড
lord,
করে দিন।
which is
the-
allotted to me by the way, my lord, Indira
The
Awas.
learned advocate for the respondent number 4 submits that after taking a loan under
Indira Awas Yojana, my lord.
under Indira Awas Yojana, the fourth respondent,
Not loan subsidy. Government subsidy, my lord.
Oh.
Government subsidy, my
I
lord.
found anywhere you have said that loan.
In the order impugned. In
So,
the order impugned, it is
The order
recorded loan.
impugned, it has been said loan.
In the order
I've read
impugned,
it
is
somewhere.
recorded, loan.
বললাম?
Indira Awas.
So how can we depart from that?
Yes, my lord. In the order impugned, it is written as loan.
দেখি, দেখি।
And in the order impugned, it is, my lord, also written, she is the owner. অর্ডারটা বের কর না বাবা, দেখো না কোথায় কি আছে।
ইন্দিরা আবাস যোজনা,
Indira Awas.
ঠিক আছে, কি বললাম? দি না, টেকিং আ লোন না করে এটাকে করুন। The learned advocate for the respondent number 4 submits that she has started construction pursuant to a scheme
ঠিক আছে।
named Indira Awas Yojana. And since the
On her property.
said respondent was prevented from making construction, the petitioner, the said respondent filed the writ petition. Full stop. He further submits that the appellant is constantly threatening the respondent number 4
Till now, my lord. Even today also.
till today. Ask your client not to
He
threaten.
is present here. He is present here, my
We
lord.
do not know. We do not.
It is
want-
not
we have
completely
not
false, my
directed
lord.
the physical
Yes.
presence of your client. Ask your client not to.
Yes,
The appellant
only submission, my lord.
is the learned advocate appearing for the appellant assures this court that the appellant or his men and agents shall not threaten the respondent number 4 in any manner. ঠিক আছে? Communicate this order because it may take some time.
I will communicate just now.
Communicate, you also communicate to your client. So it will be posted in এটা একদম সোমবার দিন।
But upon instruction, he is present, never objected anything, my lord.
That is, you instruct him. We have not directed personal appearance of your client, so you can. We have recorded your assurance. You have
Yes.
taken assurance from your client. We have recorded that assurance only.
Yes.
If there is any violation of the assurance,
Yes,
we will
yes.
consider that.
Nobody will take the burden to violate this assurance. Grateful to you. Grateful to you. Okay.